So, Donald Trump's legal team just got physically ejected from a federal courtroom after what witnesses are calling the most explosive meltdown they've ever seen from defense attorneys in a major trial. And what triggered this complete breakdown? The prosecution introduced a single email that Trump's lawyers had previously sworn under oath didn't exist. We're talking about attorneys being escorted out by federal marshals while one of them was literally shouting at the judge that this was a kangaroo court. This isn't just another contentious moment in Trump's ongoing legal battles. We're talking about licensed attorneys risking disbarment, contempt charges, and potentially their own criminal liability by melting down so spectacularly that a federal judge had no choice but to remove them from the proceeding. And trust me, when federal marshals are physically walking lawyers out of a courtroom while the judge threatens to refer them to the bar association, you know something absolutely unprecedented just went down. It's honestly hard to believe we're watching officers of the court, people who spent years in law school and passed the bar exam, completely lose their professional composure in a way that legal experts are saying could end their careers. Let me fill you in on what's been happening. Trump's legal strategy throughout this trial has relied heavily on his defense team's credibility with the court. His attorneys have been arguing that any document retention issues were inadvertent, that Trump relied on their legal advice, and that the prosecution was engaged in selective enforcement motivated by politics. For weeks, they've maintained a professional demeanor, following courtroom protocols and presenting themselves as serious lawyers defending a client against overreach. According to Politico's December 10th coverage, the defense team had successfully created doubt about some of the government's timeline evidence and had gotten several prosecution witnesses to acknowledge ambiguities in email chains and document handling procedures. The strategy was working well enough that legal analysts were saying Trump might actually have a path to reasonable doubt on some charges. But here's where the rubber meets the road. The prosecution had been building toward a specific piece of evidence for days. They'd laid groundwork through testimony about document retention policies, established timelines through phone records, and created a narrative about intentional obstruction rather than mere negligence. Then, on the morning of December 10th, prosecutors told the judge they needed to introduce a newly authenticated email that had been part of a larger document production but hadn't been presented to the jury yet. And before we go any further, let's be real for a second. When prosecutors say they have one more piece of evidence and the defense team immediately starts objecting before they've even seen it, you know, something's about to blow up spectacularly. Here's where it gets interesting. According to multiple reporters from CBS, CNN, and the Associated Press who were inside the courtroom, the prosecution handed copies of the email to the judge, the jury, and the defense table simultaneously. The email was dated August 2022, right in the middle of the period when Trump's attorneys were negotiating with the Justice Department about returning classified materials. Within seconds of the defense team reading it, the lead attorney identified in reports as Trump's primary trial counsel stood up and demanded an immediate sidebar. The judge granted it, and all the attorneys approached the bench for what was supposed to be a quiet conference out of the jury's hearing. That's when everything fell apart. According to CNN's legal correspondent, who was close enough to hear parts of the exchange, Trump's attorney raised his voice almost immediately, telling the judge that this email was fabricated and that the government was manufacturing evidence. The judge warned him to lower his voice. Instead, the attorney got louder, insisting the court needed to declare a mistrial immediately. The judge called a recess and had the jury removed from the courtroom. Once the jury was gone and the proceedings were back on the record, that's when the real explosion happened. Trump's lead counsel, now speaking directly into the microphone for the court record, accused the prosecution of withholding exculpatory evidence, manufacturing documents, and engaging in prosecutorial misconduct that he claimed rose to the level of criminal fraud on the court. The judge asked him to specify exactly what he was alleging, and the attorney made a claim that would prove to be his undoing. He stated, and this is critical, that his legal team had conducted a thorough review of all emails from that time period, and that this specific email, the one the prosecution just introduced, did not exist in any of the document productions they had received. He said his team had never seen it before this moment. Then the prosecutor stood up and dropped the bombshell. She calmly informed the court that this email had been produced to the defense in the third document production back in September, that it was specifically identified in the production index as item 4032, and that the defense had actually referenced the same email thread in one of their own pretrial motions, just conveniently leaving out the most damaging portion. The prosecutor then handed the judge a copy of the defense's own motion with the email thread number highlighted, proving they had not only received it, but had used parts of it in their own filings. The courtroom atmosphere, according to reporters present, became electric with tension. Trump's attorney's face reportedly turned bright red. Instead of backing down or asking for a moment to confer with his team, he doubled down. He insisted the prosecutor was lying, that this was a setup, and that the email in their files must have been altered after production. The judge, clearly losing patience, asked if he was accusing the prosecution of fabricating federal evidence. The attorney said, "Yes, absolutely, that's exactly what he was alleging." At this point, Trump's second-chair attorney tried to pull his colleague back to the defense table, physically tugging on his sleeve, but the lead counsel shook him off and kept going. He said the entire prosecution team should be investigated, that this was worse than anything that happened during Watergate, and that the judge was complicit if she allowed this fraudulent evidence to be shown to the jury. That's when the judge had apparently heard enough. In a voice that reporters described as icily controlled, she told Trump's attorney that he was now in contempt of court and that he needed to sit down immediately, or he would be removed. Instead of complying, the attorney said he would not be silenced, that someone needed to expose what was happening in this courtroom, and that he was willing to go to jail to protect his client's constitutional rights. The judge then looked directly at the federal marshals and said one word: remove him. Two marshals approached the defense table, and that's when the second attorney also stood up and started shouting that this was a violation of Trump's Sixth Amendment right to counsel, and that the judge was proving the whole system was rigged against them. The judge held up her hand, pointed at the second attorney, and said, "Him too." Both attorneys were escorted out of the courtroom while one of them shouted back at the judge that this was a kangaroo court and that everyone would see the truth. The remaining member of Trump's legal team, a junior attorney, sat frozen at the defense table, apparently in shock at what had just happened. Now, this isn't the first time we've seen Trump's attorneys find themselves in impossible positions that destroy their professional reputations. Just think about how Rudy Giuliani went from America's mayor to a disbarred lawyer facing bankruptcy after he spent years making false claims about election fraud on Trump's behalf. Giuliani destroyed a decades-long reputation, lost his law license in New York and D.C., and was hit with a $148 million defamation judgment, all because he couldn't stop lying for Trump, even when the evidence proved he was wrong. Then there was Sidney Powell, who made such outrageous claims about voting machines that she faced defamation suits, eventual criminal charges in Georgia, and became a national laughingstock in legal circles. Powell went from being a respected federal prosecutor to someone whose name became synonymous with conspiracy theories and baseless allegations. And let's not forget Jenna Ellis, who pleaded guilty in the Georgia case and had to publicly acknowledge that she made false statements about the 2020 election. Ellis was censured by the Colorado bar, admitted she relied on what others told her without verifying facts, and essentially confessed that her representation of Trump led her to violate her professional obligations. Even John Eastman, the attorney who wrote the memo outlining how Pence could refuse to certify electoral votes, is facing disbarment proceedings in California and criminal charges in other jurisdictions. Eastman's entire legal career is in ruins because he provided Trump with a legal theory that every serious constitutional scholar said was baseless. Now, it looks like Trump's current trial attorneys are joining this list of lawyers who thought they could bend the rules, make outrageous claims, and face no consequences as long as they were doing it for Trump. The pattern is absolutely consistent. Every attorney who goes all in on defending Trump through tactics that cross ethical lines ends up destroyed professionally. So, what specifically did these attorneys do that was so far beyond the pale that immediate ejection was the only option? Well, it all boils down to making a factual claim to the court that was demonstrably false and then refusing to back down when confronted with proof of the lie. According to legal ethics experts who spoke to multiple outlets, attorneys have a duty of candor to the tribunal. That means you cannot knowingly make false statements to a judge. When Trump's lead attorney claimed his team had never received that email, he made a factual representation to the court. When the prosecutor immediately proved that was false by showing the production records in the defense's own motion, citing that email thread, the attorney had a professional obligation to acknowledge the error, apologize, and move on. Instead, he accused the prosecutors of fabricating evidence, which is itself an incredibly serious allegation that requires actual proof, not just defensive deflection. Now, here's the kicker. The judge asked him point blank if he was formally accusing the government of manufacturing evidence, giving him a chance to walk it back. He said yes. At that moment, according to legal analysts, he crossed a line that no competent attorney crosses. You don't accuse prosecutors of criminal conduct without extraordinary evidence, especially not when the record clearly shows your own statement was false. The judge then gave him a direct order to sit down and be quiet. Another chance to stop the spiral. He refused. At that point, ejection wasn't just justified, it was mandatory. A judge cannot allow an attorney to continue disrupting proceedings, making false statements, and refusing direct orders. The courtroom has to function, and that requires a baseline of professional behavior. Legal experts noted that the second attorney's decision to also start shouting sealed his fate immediately. Once the judge has ordered someone removed and you stand up to join the chaos, you're making a choice to be removed as well. This leaves Trump in an extraordinarily difficult position. On one side, he now has to continue a complex federal trial with only a junior attorney who wasn't prepared to be lead counsel. That attorney has to somehow manage the rest of the trial, handle cross-examinations, make legal arguments, and protect Trump's interests without the benefit of the preparation and strategy that the now ejected attorneys had developed. That's nearly impossible in a trial this significant. On the flip side, Trump's entire defense strategy just collapsed in the most public and damaging way possible. His attorneys didn't just lose an argument. They got thrown out of court for lying and throwing a tantrum. That's the image jurors are left with. That's what will be in their minds when they deliberate. The message it sends is that Trump's defense was so weak, so indefensible, that his own lawyers melted down rather than face the evidence. The tricky part is there's no way to undo this. So Trump is caught in a bind. He can either bring in new attorneys mid-trial, which means asking for a continuance that the judge is extremely unlikely to grant. And even if she did, starting over would mean the jury sees that Trump's original legal team imploded so badly he needed a complete replacement. That doesn't inspire confidence. Or he can continue with the remaining junior attorney, supplemented perhaps by someone from his broader legal team. But that means going forward severely undermanned against experienced federal prosecutors who just scored a massive psychological victory. Every option is terrible. The defense just suffered perhaps the most damaging self-inflicted wound possible in a criminal trial. This whole scenario is causing absolute chaos throughout Trump world and the broader legal community. According to reporting from multiple outlets, the conservative legal movement is split between those defending the attorney's passion and those horrified by their lack of professionalism. Some Trump supporters online are claiming the ejection proves the trial is rigged and that Trump's lawyers were removed because they were winning. Others, including some conservative attorneys, are openly questioning how these lawyers thought this strategy could possibly help their client. Fox News legal analyst Jonathan Turley, who has often defended Trump's legal positions, appeared visibly uncomfortable when discussing the incident. He acknowledged that while attorneys can and should fight hard for their clients, making demonstrably false statements to a judge, and then doubling down when caught crosses every ethical line, when even friendly legal commentators are struggling to defend your attorney's behavior, that tells you how bad it really was. Meanwhile, the legal ethics community is unified in condemning what happened. According to former prosecutors and defense attorneys from across the political spectrum, speaking to various outlets, this was career-ending conduct. These attorneys will almost certainly face bar complaints, could be held in contempt beyond just the immediate ejection, and might face sanctions, including fines or suspension of their licenses. Andrew Weissman, former FBI general counsel and prosecutor, said on MSNBC that in his decades of practice he'd never seen anything quite like this. He noted that the combination of making false statements, accusing prosecutors of crimes without evidence, and refusing a judge's direct order would typically result in referral to the state bar and potentially criminal contempt proceedings. Things became even more intense when during the lunch recess, Trump posted on Truth Social, attacking the judge personally, calling her a partisan hack and saying his attorneys were heroes for standing up to corruption. Legal experts immediately noted that Trump attacking the judge while his attorneys were just removed for similar behavior showed he either doesn't understand or doesn't care about the consequences of courtroom misconduct. Former federal judge Nancy Gertner told CNN that Trump's statement could be used as evidence that the attorney's behavior was part of a deliberate strategy to create appealable error and manufacture a mistrial, which could actually make the situation worse for everyone involved if the judge decides to explore whether this was coordinated contempt. Let's break down what legal and ethics experts are saying about this unprecedented moment, because the implications go far beyond one bad day in court. First, there's the immediate question of how Trump continues this trial. According to veteran trial attorneys, losing your entire prepared legal team mid-trial is catastrophic. The remaining attorney doesn't have the same command of the evidence, hasn't prepared the cross-examinations, and doesn't have the strategic framework that was developed over months. That puts Trump at a severe disadvantage for the remainder of the trial. Some legal analysts told Politico that Trump should seriously consider whether he wants to take the stand in his own defense now, because without experienced attorneys to prep him and guide his testimony, the risk of self-incrimination increases dramatically. Second, there's the bar ethics dimension. Multiple state bar associations could open investigations into these attorneys' conduct. According to legal ethics professor Stephen Gillers, at NYU Law School, making false statements to a tribunal is one of the most serious violations possible. He told the Washington Post that attorneys can be disbarred for less egregious conduct, and that the public nature of this meltdown, the clear record of what was said, makes defense of their actions nearly impossible. They can't claim it was a misunderstanding or a heat-of-the-moment mistake. They made specific factual representations that were immediately disproven, then escalated rather than correcting course. Third, there are the criminal contempt implications. The judge could refer both attorneys for criminal contempt proceedings, which carry potential jail time. While that's rare for attorney misconduct, according to former prosecutors, refusing a direct court order after being found in contempt moves the situation into that territory. The attorneys might have to hire their own criminal defense lawyers to defend against contempt charges stemming from their conduct in defending Trump. So let's break down what this could mean, because it's not just about two lawyers having a bad day. It has serious consequences for Trump's immediate legal situation, the broader pattern of attorney misconduct in his cases, and the integrity of the judicial system. First up is the immediate trial impact. Trump now faces the remainder of his trial. with a severely weakened legal team right after the prosecution introduced apparently devastating evidence and after the jury watched his attorneys get physically removed from the courtroom for making false statements and throwing a tantrum. Legal observers who have been following the trial told multiple outlets that this single incident may have eliminated whatever chance Trump had at acquittal. Juries tend to draw negative inferences when defense attorneys behave this way. It suggests desperation and consciousness of guilt. Looking ahead to the broader implications for Trump's other cases, this incident could affect how attorneys approach representation of Trump going forward. Competent lawyers are going to be extremely hesitant to take on his cases if they see that it requires making statements that could cost them their licenses. According to reporting from Reuters, several law firms that were considering representation in Trump's other matters have now declined, citing concerns about whether they could maintain ethical representation given Trump's demands in public statements. The pool of qualified attorneys willing to represent Trump keeps shrinking with each incident like this. And beyond Trump specifically, this sends a message to all attorneys about the consequences of letting client loyalty override professional obligations. Bar associations and judges are watching these Trump cases closely. The message being sent is clear. You cannot lie to judges, you cannot make baseless accusations, and you cannot refuse court orders, no matter who your client is or how high profile the case. It's about so much more than just this trial. It's about whether the legal system can function when attorneys abandon professional standards in service of a client's scorched earth strategy. If these attorneys face no meaningful consequences, if they can lie to a judge, accuse prosecutors of crimes, refuse direct orders, and just pay a fine or get a slap on the wrist, then we're basically saying courtroom rules don't really matter if you're representing someone powerful enough. That would mean we've entered a realm where the most aggressive and unethical legal tactics become the norm because there's no real downside. This isn't just about Trump's attorneys. It's about whether every attorney, regardless of their client's status, has to follow the same rules of professional conduct. So, here's the deal. Donald Trump's attorneys got physically ejected from federal court by marshals after they made demonstrably false statements to the judge, accused prosecutors of manufacturing evidence without proof, and refused direct orders to sit down and be quiet. This isn't just about one courtroom meltdown. It's about the complete breakdown of professional standards that seems to follow everyone who enters Trump's orbit. When your lawyers would rather get dragged out of court than face the evidence against you, that tells the jury everything they need to know about the strength of your defense. If these attorneys face no serious consequences, then we're saying there are no real rules for lawyers representing powerful clients. The next few days are going to be crucial. Trump has to figure out how to finish this trial with a decimated legal team. The ejected attorneys have to face potential bar complaints and contempt proceedings. And the jury has to decide what they just witnessed and what it means for the credibility of the defense. The stakes have never been higher, the consequences for attorney misconduct never more public, and the path forward never more unpredictable for everyone involved. Keep an eye on this.